Hello and welcome to the Daily Newspaper Analysis, an initiative of the UPSConline.com and Ambition IAS. Today we shall be discussing the newspaper of the 21st of December 2017. So coming to the first article, the entire editorial for this day, that is the 21st of December, is an important one. So the first article is that of reconsider the rules. The 2017 wetland rules limit monitoring and omit important wetland types. Now, basically the context is that of Wetland Conservation and Management Rules 2017. These rules have been given to replace the previous 2010 rules. So that is the context, and the article is about an analysis of these new rules about wetlands in general. So that is the entire context. Coming to the issues that have been discussed, the first issue is that firstly, I'll just give you a brief history that even recently the Supreme Court had passed an order directing states to identify their wetlands in the country within a stipulated time frame. So focus on wetland conservation is gathering speed in the country. We all know that previously there is something called Ramsar Convention on wetland conservation. This is an international convention. This is an international convention on wetland conservation. So now speed is being gathered on the front of wetland conservation, both by the central government, which has stipulated these new rules, as well as the Supreme Court. Now coming to the issues, first and foremost, the 2017 rules have been criticized for doing away with a strong wetland monitoring system and omitting important wetland types. This is the opinion that the author has held. So this is a direct criticism that the monitoring agency has been done away with. Also, both these 2010 rules as well as the 2017 rules have given a term something called ecological character. This is a key word because the ecological character is an all-encompassing term. It focuses on not only the geographic aspect of wetlands, it focuses upon the biodiversity, the fauna, flora, and so many other ecological benefits. So this is something called ecological character, which is an all-encompassing term. So the issue is that both 2017 as well as 2010 rules did recognize this thing called ecological character, but the idea becomes all-encompassing, so it is a challenge to implement these rules. So that is the concern. Another thing is that in 2010 some related criteria were made explicit. For example, natural beauty, ecological sensitivity, genetic diversity, historical values. This has been omitted in the 2017 rules. So this is an important criticism of these rules. Now the issue that has been raised by the author is that there are multiple interests around wetlands and not mere a geographic or an environmental character. So it is important to identify these multiple interests and map these and multiple uses of wetlands and then have a holistic approach in their conservation. So that is a good idea that the author has brought out. Another thing is that there's a principle of wise use. Because wise use are certain activities which can be allowed in the wetland areas based upon the criteria that are they under the ambit of wide use. But the issue is that these wide use, this clause of wide use has to be determined by the states, and so the states are responsible for regulating activities around wetlands. So the issue is that this can be misused by certain states and certain important protective measures can be done away with. So this is certain area of debate. Another thing is that under new rules there is no authority to issue directions which are binding in nature to desist from any activity detrimental to the wetland conservation. So this is important because a monitoring body, a strict monitoring body is being absent here. So that is another major flaw with this 2017 rules. Then further, the author brings about two case studies, which is important. One of salt pans. Here the author says that salt pans are the areas from where salt is extracted, and these salt pans are also a form of wetlands. But the issue is that the 2017 rules have not considered the salt pan as wetlands, and not only are these salt pans being used aggressively for salt manufacturing, this is hampering the salt pans with regards to the biodiversity, because the salt pans are source for attraction for migratory birds. Also, they have a very specific flora and fauna associated in the salt pan area. So it should have been included, but it has not been included. So that is one case. Another case is that of the Deepor Beal case. This is important because this is a case for which the NGT has given a judgment. So the Deepor Beal is a wetland. It's a Ramsar wetland. In India, we have 26 Ramsar sites. You should know that, and you should learn these 26 sites for prelims point of view. So Deepor Beal is in Assam. Now, what has happened with this wetland is that this wetland has been continuously facing destruction at the hands of municipal dumping of waste. So it is being said that the waste was dumped near to the wetland, so the wetland was being choked of its tributaries, it was being choked of its channels. So that is one issue, and the NGT has given a judgment recently that the Deepor Beal should be restored to its historical status, what it had in the past. So that is one thing about this case. This case becomes important if you have to discuss NGT. It becomes important if you have to discuss wetlands. It also becomes important if you have to discuss environment in any answer. This is a good case study. It is a very good example. So that is one thing. Also, the author has come up with some wonderful suggestions, which I would suggest that you should note down. The first is that the author suggests that there should be some idea of traditional cartography to understand catchments of wetlands. So this is important because what the wetlands were in the past, today the focus is on conserving what the wetlands are left. So that is of no importance because the wetlands have already shrunk, and also the channels of these wetlands have died out. So even if you conserve of what remains, the wetland will slowly die a death of its own if focus is not given on the historic spread of the wetland. So these are some key words: traditional cartographic analysis and historic spread. These are key words which can be used. Another thing that the author suggests is that restoring the ecological character, which I had said, that is a wholesome maintenance of these wetlands. Another thing is that identity or rights to wetlands, just like in the case of the river Ganga and Yamuna. The author even starts her article by that Ganga and Yamuna have been given the status of living entities. So the author is saying that critically damaged wetlands should be given the status of living entities on the grounds of Ganga and Yamuna, and they should be given certain rights. So that is a good suggestion, can be used in your answers. Also, there should be a clear governance system for wetland conservation, and these loopholes of no monitoring body and these kind of loopholes in the system should be plugged. And the author says that addressing challenges of identification of wetlands is another important thing, and also these wise use criteria. So these identification of wetlands and right use areas is something that is in the ambit of states. So effort should be made to ensure that they are done rigorously, they are done with utmost prudence. So that is a suggestion that the author has given. Now coming to the second article, this is a column article and a very important one. This is upon the issue of archaic laws. Now, a lot of laws in India are archaic, they are old, they are not relevant. However, they continue to be in the law books, in the statute books. So the article is a summary of that. First and foremost, I would like to give you a key statement that is given in the first line itself. It says that if lawmaking is a long and tedious process, it appears that unmaking of laws is equally arduous. Now, this is a very good statement, and this can be used in essays, this can be used in answers. It is an impressive statement. When you come across such a statement, you can note it down. Now, coming to the background, there are a large number of obsolete laws, and also in the last 3 years, the government has been aggressively focusing on removing or doing away or repealing these laws. So this article becomes relevant in that case. So some issues have been raised by the author. These issues are that first and foremost, there is an absence of periodic review of laws in India. So that is one thing. Another is that these laws are not in tune with the modern democratic ethos of the country. It is important that the modern spirit of the constitution should be fulfilled through its laws. These laws are not in those lines. Further, I'll take some examples so it will become more clear. Also, why it is not democratic? Because there are some controversial laws. For example, laws on sedition or inciting disaffection against the state. These laws were of the time of British government, of sedition and all, but they continue and they are being debated time and again because there are many arrests being made on the grounds of these laws, and sometimes normal freedom of speech of citizens is being hampered upon, and they're being harassed. Citizens are being harassed by police officials. So that is one thing. It is being misused by politicians. That is another thing. Sedition laws are very much in use. It is important that you mention them under the ambit of archaic laws. Also, laws recently, we had done an article on dealing with adultery. Adultery is still a criminal law in this country, whereas all of the globe it is a civil law. It is a law related to marriage, and adultery should at the most lead to divorce. It should not lead to criminal penalty for a person, because societies have changed. Times have changed, and adultery has become a very though not a welcome one, I wouldn't say that it's a good thing, but it is a very common thing now. So many experts are advocating that it should become a civil matter and not a criminal matter. Another thing is relating to Article 377, very much in use for LGBT society is advocating that this article should be repealed, because it criminalizes unnatural sex in the society. So that is one thing. This was a law under the British government, and these laws have been even changed by the British government, but they continue to be in India. So these are the controversial laws here. Also, certain bodies like the Law Commission of India and a committee in 1998 by the name of PC Jain Commission raised the issue and has recommended the withdrawal of many of these laws. So time and again, recommendations are coming for the withdrawal, but still, the pace at which these laws should be removed is not something that is being seen. These laws can further be misused and invoked against innocent law-abiding citizens, as we've seen in the case of sedition, and also the misuse of Article 377. Further, this is a core requirement for good governance, because an updated and trimmed statute book will ensure better understanding and clarity of action for government officials, and this will be this will have direct results on good governance. Further, there is a good suggestion that the author has made, that there should be a permanent commission. This is a good suggestion, that a permanent commission which should continuously review laws, and it should suggest for repealing of laws which need to be repealed. So the permanent commission to resolve this issue, that's a good suggestion. Now coming to the application part, directly whenever you have to apply on archaic laws or laws on sedition and all, you can use this. That is the direct application. Coming to the indirect application, this has a very good application in judicial reforms. Time and again we are dealing with the topic of judicial reforms, because it is one of the most important problems faced by the country. So whenever you get an opportunity to discuss judicial reforms, you can bring out this issue of archaic laws. So there this becomes important. Coming to the next article, this is an important article, because it is about the Financial Resolution and Deposit Insurance Bill. Now, this bill has been in use for all the wrong reasons, especially its clause of the bail-in issue, which many people are saying is discriminatory to the users and discriminatory to the common depositors in any bank. So that is why this is an article which justifies FRDI bill. It gives that why the bail-in clause is not all that demonic as it has been quoted by many. So that way it gives a new opinion. That is why I've said that this is an important article. So as we all know that recently the FRDI bill has been introduced, and it has a clause of bailing in the banks. Now first and foremost, what is the need for an FRDI bill? This is a wonderful analysis that the author has drawn. Now the issue of bankruptcy in our country is very, very important. Also, a few years back, the Economic Survey had a chapter on Chakravyuh, where it said that the problem is that many company focuses are shifting on startups, but focus is not on exiting, quitting, leaving. So those are major problems. For it should not only be an ease of doing business or ease of starting a business, it should also be an ease of exiting a business, which should be focused upon. So in tune with these opinions, the government has come up with a bankruptcy insolvency code for corporates. But this bankruptcy can also happen for banks itself, not for a corporation, but in case of banks. Now, the author says that whenever a bank goes bankrupt, in that case, the ramifications are much more as compared to the bankruptcy of a corporation. Why? Because the people's faith in the banking system is of utmost importance. So if a bank fails, this faith in the financial system of the country is eroded, and so a bankruptcy of a bank is a much more systemic issue than the bankruptcy of any corporate. And it is in this backdrop that laws dealing with the bankruptcy of banks have to be different from the laws which deal with the bankruptcy of corporations. So this is the need of the FRDI bill, which envisages the bankruptcy proceedings in case of banks. So that is the whole need. Coming to the certain issues which the author has raised, some nice issues the author has raised regarding the FRDI bill. She says that the bill will bring a system of risk-based monitoring of financial institutions. This I have told you even in the need. That is, it is a monitoring of risk-based monitoring of the financial institution. What will happen is that as the financial institution will move towards a risk, higher the risk, a different approach will be used for monitoring. So the greater the risk, different will be the monitoring approach. So that is what the author has said. Now at the stage of critical risk, when the risk will be at its most critical point, when the bank will be just at the verge of defaulting, at that point something called a resolution corporation will be formed. Resolution corporation. Now it is this resolution corporation which will take away the power from the bank heads, and then it will decide upon the criteria of what has to be done in such a situation. So this is the idea that the act has, and it is this resolution corporation which will also decide on the idea of bailing in of a bank. So this is what the author has brought about. Then she says that the tool can only be used in consultation with the regulator, and in this case the regulator will be RBI. Now people are really fearing in with this idea of bail-in, which means that if the bank has defaulted, so the liabilities of the bank, which was nothing but the deposits of the depositors, can be used to bail the bank out of this situation. So bail in and bail out is different, because bailout is when the government gives money to the bank. That is also public money, that is the money of the exchequer. But in this case, bail in, it is directly the money of the depositors in that bank. So this is one issue which the author is trying to say, that what are the safeguards for this bail in. She says that firstly, it is not going to be decided by the bank owners, because it is going to be decided by an independent body, that is going to be the resolution corporation. Also this is going to be in consultation with the RBI. Further, she says that there is a clause that takes power away from the failed institution, this resolution corporation, and the importance is that first there are some safeguards to this bail-in tool, which she says is like that such liabilities can be bailed in which there is a bail-in clause. Now before a liability is signed, suppose before I am depositing my money in a bank, I will be made aware of the fact that the money, the program under which I am depositing my money in the bank, whether it is under the bail-in clause or no. And as a result of which, if I give my consent that in case the bank defaults and there is a need for bail-in, should my money be used as a bail-in, this opportunity to decide is with the depositor. So that way there is a protection, that there is a provision for consent. All right, and also this information that which liabilities will come under the bail-in clause, this information is very much in the public domain. So it is not that something from the hindsight will come and take the citizens' money. It is very much going to be open in a transparent process. So that is one safeguard. Also, it will be incumbent upon the resolution corporation to follow a prescribed route. They cannot just suddenly decide for one bank that whether this bank should be bailed in and other should not. There is a prescribed route, and so this does away with the whole debate. There was a debate of inequity and moral hazard related to bailout procedures by the government. This happened even in the case of US, when in 2008 the Lehman Brothers crisis, Lehman Brothers was not bailed out, whereas after that many such institutions were bailed out. So this discriminatory power of the government is done away with, because there is a completely prescribed route as to what should be done. So this is another safeguard. Thirdly, the bill gives the aggrieved person a right to be compensated by the resolution corporation if any safeguards are not followed during bail-in or in the conduct of any other resolution action. So safeguards are there. There is a mechanism of compensation. That is important. Another thing is that the law provides for a before the event consent for certain liabilities to be built in. This I mentioned before also. This is a safeguard that the author has time and again brought about. Also, when the author brings about a comparison with some other countries, and she compares it, the case with European Union, and she says that just in the case of European Union, the laws regarding bail-in are much more stringent and not so citizen friendly as in the case of India. So India has adopted a much higher standard of law dealing with bankrupt cases of banks themselves, failing financial institutions. So in that case, this is a good point. Even you can give in your answers that compared to global laws, India's laws are much more citizen or depositor favoring. So that is one thing. Now, yeah, that's about this article. So this is a good analysis of the positives of FRDI, which you should know, as I've always mentioned, that whenever there is a debatable topic like FRDI itself, you will have both the pros and cons. So this is a good article about the pros of this. The cons, we have come across many articles, but this is a good one on the pros. So you can, note these points down. Coming to the next article. This is a small article, but I found it important, so I mentioned it here. Basically, this is one on science society interface. Now, whenever you have an opportunity to discuss research and development in the country, this article becomes important because the thrust of the government is also that research and development of scientific inventions and innovations should be in line with the need of the society. This is something that has been echoed by the Prime Minister time and again, that scientists should come and meet the farmers, they should meet the poor people, and they should come up with solutions, scientific solution to their problems. So this is important from that perspective. Now, what is the context of this article is that a scientist, a physicist named Mr. Ravi Kuchimanchi has recently won the the Sakharov Award by the American Physics Society. Now, this award is an award which recognizes outstanding leadership or achievement of scientists in upholding human rights. So, it is not for any scientific achievement, but a scientist's contribution to human rights. And recently, an Indian named Ravi Kachimunchi, who is a scientist settled in USA, this topic also becomes from scientific diaspora. He's India's diaspora. He has won this award because he has founded an association for India's development more than 20 years back. And also it has 1,000 volunteers it has, and in every year it is raising funds up to $22 million. So that this is important. And the movie Swades, this is one thing I have mentioned this article for this reason. So movie Swades had a character of Shah Rukh Khan where he played the role of a scientist who brings about electricity in a small village of Maharashtra. So that is largely based on this scientist's efforts. It was inspired from here. So now some of you might just think that why mention a particular movie? How is it important for UPSC? But my personal experience with UPSC answering is that they have always welcomed innovation in answers itself. Something different. If you bring out this concept of Swades movie, even in essays, or if you get an opportunity to bring this idea out and link it to the societal needs, it is always a welcome approach. It will be awarded in UPSC. So this is a good example. That is why I mentioned it. That's about this article, that he has the issues that are there is, first and foremost, that we are not recognizing our own scientists. Recently I had few days back there was another article on science and technology, and that we are not recognizing our scientists. So this is important from that point of view, that we should recognize Indian scientists. Another issue is that of science society interface, that it is not happening so much in India, but this is a good example and it should happen in such scenarios. So, and the movies for this can be used in essays, you can use it in answers as an example. So yeah, the next article is Wait and Watch. Basically, this is an article on the India-US relationship, and it is in the context of the recently announced national security strategy by President Trump. National security strategy for US has been announced by their president, Donald Trump, and in this strategy, he has, given India the stature of a global power, a leading global power. Also, it has marked a shift in considering India as a balancing power to a global power now. Further, the opinion is that criticism has been given to countries like Pakistan for funding terrorism, also to China for its aggressive, inroads into South Asian countries, also its attitude in the South China Sea. So that is there. The entire strategy, national security strategy of US is in alignment with India's vision, and this is a boost for India-US relationships. Some keywords I have found in the article which are important. That China has called this step by US as a zero-sum game and a Cold War mindset. Also, Russia has called it imperialistic. So these are some keywords. If opportunity provides, you can use them in your answers. Now, the issues here are, firstly, India has welcomed acknowledging China's assertive role in South Asia and Pakistan's terror activities. India has welcomed these. Also, the credence given to India in the strategy is a welcome step for India. So that one thing you have to understand. Secondly, the issue is that there is a lack of stability in Trump's policies. This is being seen internationally. Even if Donald Trump has made this commitment to India that India will be a partner, a global partner of US as a global power, one cannot really trust it because there is a trust deficit with the US, considering its approaches in international treaties like the Trans-Pacific Partnership Agreement as well as on climate change. So, on those issues, also I have time and again mentioned that despite the warming of India-US, you have to understand that they have deep differences on global fora, like recently we saw on WTO, also in the UN. So these kind of points need to be remembered. Another thing is that despite USA's criticism of China and Pakistan, this criticism is not being translated into action. Why? Because US is not, if US is criticizing China for having infrastructural investments in South Asia, this is not something that US is supporting by funding infrastructure projects in South Asia itself. It is merely criticizing China but not taking any action. Also, with relation to Pakistan, it is criticizing Pakistan for its actions, but it is not cutting funding for Pakistan terrorist programs. So that is one thing. Also, the opinion that the author has given here is a good one, and that I would suggest you should make note of. He says that a wait and watch approach to preserve the autonomous and pluralist nature of India's engagement is a must. So he has used two keywords. One is autonomous and the other is pluralist. So these are the policies that India is following, and it should not engage with a particular country. So the importance of the article is in general with India-US relations, India's role as a global leader. Whenever you have to discuss that, you can lay claim to the fact that even in the national security strategy of US, India has been acknowledged as a global leader. Another thing is that it becomes important in the non-aligned movement questions. Whenever there is a question on this, that India should act cautiously and should follow its policy of autonomous and pluralist approach in foreign relations in general. This article becomes important. So with this, we finish today's discussion. I thank you all for watching this video. I hope you'll recommend it to your friends, and we shall be welcoming your feedback. So thank you once again. See you tomorrow.